Cases are adjourned for few cases. Serial number 2, the State of Bihar versus Ram Tawakal Singh. For the appellant, Sri Sanjay Prasad, Sri Anjani Kumar.
May I please, your lords? Here is the case, my lord, wherein, my lord, may I draw your lordship's kind attention towards the orders passed in this case. Order number 4 dated 8/1/20 and the previous order, my lord, where under, my lord, the LPA came to be admitted and the stay has been granted. Limitation petition, my lord, has been allowed, limitation condoned.
Who is for the respondent? Ready?
My lord, may I draw your lordship's kind attention towards the order passed by the Honorable Single Judge, my lord.
Sir, before that you have to give the dates and events, matter relating to departmental inquiry.
My lord, perhaps your lordship may not like to go into all these because, my lord, here is the submission made on on behalf of the estate, that while setting aside the order of punishment, the learned single judge, my lord, ought to have remanded back the matter to the disciplinary authority for further proceeding, because on technical ground, my lord, it came to be quashed. This is the sole issue, my lord, which I will make submissions for your lordship's kind consideration. My lord, if your lordship will see, my lord, 23/11/2017, and finding your lordship will find, my lord, at page 3 of that order, at the bottom, my lord, having heard the submission of both sides, the sole question arises for consideration as to whether the report of the inquiry officer without being produced, any evidence by the presenting officer as required under sub-rule 14, rule 17 on perusal of records not brought on record in accordance with law is legal, and any punishment can be inflicted on such report. It is important to reproduce sub-rule 14 of rule 17, which is as follows. On the date fixed for the inquiry, the oral and documentary evidence by which the articles of charge are proposed to be proved shall be produced by or on behalf of the disciplinary authority. The witnesses shall be examined by or on behalf of the presenting officer and may be cross-examined by or on behalf of the government servant. The presenting officer shall be entitled to re-examine the witnesses on any points on which they have been cross-examined, but not on any new matter, without the leave of the inquiry authority. The inquiry authority may also put such questions to the witnesses as it thinks fit. From bare perusal of sub-rule 14 and different sub-rule of rule 17, it is crystal clear that the legislature has prescribed the procedure for holding departmental inquiry in the prescribed manner. It is needless to say that violations of the procedure meant for holding departmental proceeding amounts to violation of natural justice, and if inquiry is held in contravention of any provisions of Rule 17 meant for holding departmental inquiry, the inquiry report as well as the punishment thereon shall be vitiated. It is evident that the proceeding was initiated on the basis of inquiry report of Technical Committee of the Vigilance Department. The petitioner was served with the article of charge containing 6 charges on the basis of the inquiry report of the Technical Committee. The petitioner submitted his detailed so cause, but the disciplinary authority was not satisfied with the, I'm correcting it, with the so cause and the petitioner, so cause of the petitioner, and ordered for initiation of proceeding under Rule 43B of the Bihar Pension Rules. The disciplinary authority appointed additional inquiry commissioner to hold the inquiry. The inquiry report in Annexure 5 shows that the inquiry officer considered the so cause and the submissions of the presenting officer, but does not appear that the presenting officer during the course of inquiry brought on record. I would be emphasizing this because this is the reason which led to quashing of the order of punishment. But it does not appear that the presenting officer during the course of inquiry brought on record any documentary evidence in accordance with law as required under sub-rule 14 of Rule 17. The presenting officer is bound to bring on any document in accordance with law, and that should have been marked as exhibit. Thereafter, my lord, after 2 lines, it further appears that the presenting officer did not even examine the member of the committee who held preliminary inquiry, on the basis of which the proceeding under Rule 43B of the Bihar of the pension rules was initiated against the petitioner. Unless the author of the report is examined, the petitioner was allowed to cross-examine the author of the report on the basis of which the proceeding was initiated. The finding of inquiry officer with regard to guilt and punishment, so and so, so and so, and that led to, my lord, setting aside the order of punishment. Since your lordship has been pleased to see, my lord, the rule, and, my lord, it seems from the record, my lord, that it has not been followed. Sub-rule 14, my lord, of 17, that has not been followed, my lord. Kindly see, my lord, one judgment. I have given the list of books. 1993, volume 4, SCC 227. Managing Director, ECIL, Hyderabad and others versus B. Karunakar and others.
We are aware.
Yes. Then,
Then
Well-
Coal India.
only one line.
No, Coal India.
Yes.
Coal India has reiterated.
This
If
says,
the discipline, if punishment order is set aside on technicality, it has to be remanded.
bus, okay.
That's all. Yes. At least
My
you
lord.
can, he is not in a position to give the dates. At least you are in a position to give the dates. What is the date of charge memo?
Date of retirement, my lord, 36/2008.
Huh?
Petitioner retire on 36/2008.
30?
6/2008.
3.
6 3
6 2000?
8.
I am asking you what is the date of charge memo?
And a letter received by the petitioner on 5/11/2009.
5/11
2009.
charge memo.
Yes, my lord. Asking a so called, my lord, by the annexure 1.
Are you sure? 5/11/2009.
Yes, my lord. It is written in the order, my lord, itself.
What is the
written-
charge?
Charge is, my lord, some measurement was calculated after retirement of the petitioner, since the fill up of the canal was found, it is not a proper way to
What is the
assess
loss
by-
cost to the state
that-
exchequer?
That has not assessed. They have cost, my lord, that at the time of retirement, the petitioner, the contractor has not paid the amount.
Where is the charge memo?
In the read, my lord.
Annexure 1 series at page 26.
Annexure 1 is the inquiry, my lord, by the
Page 26.
Arop Patra, page 29, my lord.
29 है.
29.
Yes, your lordship, I stand
Page
corrected.
29.
Sir, page?
29, my lord. इसमें है कि उपरोक्त
Where is the charge?
पेज 29, my lord, आरोप पत्र पेज in the writ petition, my lord. Page
What is page number 25 and all?
It is an inquiry, my lord, held by the department.
No, what is page number 25? Some calculation is made.
Yes, my lord. In the inquiry made by the department, this calculation has been made.
Annexure 1 series, my lord, at page 18 is the technical inquiry cell inquiry report, 11/9/2008.
And in that inquiry, it has been stated, my lord, कि loss caused 15,75,390 will be recovered from the contractor. Page 25, my lord, it has been written. And the contractor returned the amount, my lord, which was lost, 15,75,000. The contractor
Construction of that dam or inspection.
That is 2008.
2008. 2008. Yes. 2009 charge memo was issued and the penalty was imposed in why we should remand the matter? We are left and there is no financial loss. So on these points, this matter, who, no, on the charge memo it is evident, no? We have to go by charge memo. We can't say that beyond this charge memo.
Yes.
Payment has not made to the contractor or full and final till the date of retirement of the prisoner. Thereafter, the amount has been recovered from the contractor.
How much? 15 lakhs 75. Then the district will remand this.
We will remand the matter. Go and
Lord,
face inquiry.
My lord, petitioner
We'll,
retired.
we'll stipulate
It is not-
within 3 months they have to
Time,
conclude.
within time frame.
My lord,
Because of your allegation is certain measurement and quality has not been taken into consideration, thereby loss has cost to the state
then
exchequer.
loss has not caused, my lord.
15 lakhs
15 lakhs
No, that has been
75,000.
recovered from the contractor, my lord. It has, that has not been
Recovered
paid.
from the-
That has not been paid. It is written in the report, my lord. Page
No, where
20,
is the
page
recovery?
25, may kindly see, my
No,
lord.
where is the recovery? Recovered from the contractor according to you. It has been recovered from the contractor.
It is written in the page
Extra
25, may
payment
kindly.
was made, that allegation is against
Page
you.
25, may kindly see, my
Sir,
lord. It is
extra
Hindi, my lord.
payment was
So,
made, that allegation is against you. Allegation of payment of 15 lakh 75,319 rupees. That is against you. You say that subsequently the contractor repaid the amount.
till the date of retirement, my lord, final payment has not been made. Final payment, final and full measurement has not been
Yes,
done.
inquiry and let
And
them conclude
In
the
the
same.
inquiry you prove it.
Yes. That payment was, the contractor returned the amount.
We'll direct them to complete the inquiry within 3 months.
My lord, prisoner retired in 2008, my lord.
So what? So what?
And department had recovered that amount from the contractor, my lord. As per
You cannot excuse yourself only because the money has been returned to the department.
You are an executive engineer, retired executive engineer.
retired executive engineer, my lord.
Case taken. The instant appeal, the apparent state has assailed the order of the learned single judge dated 23/11/2017, passed in CWJC 8589 of 2014. Full stop. Next, respondent, while working as an executive engineer on certain allegations relating to construction of a dam in the year 2008 and 9, an inspection was conducted. Full stop. In terms of inspection report, they found certain misdeeds, alleged misdeeds is stated to have committed by the respondent. Full stop. Thereafter, the disciplinary authority initiated inquiry while framing 6 charges on 5/11/2009. The inquiry was completed and proceeded to impose the penalty of withholding of 40% pension for a period of 10 years on 15/3/2013. Full stop. Feeling aggrieved and dissatisfied with the order of punishment dated 15/3/2013, the respondent preferred CWJC 8589 of 2014. Full stop. The learned single judge allowed the petition on 23/11/2017 while setting aside the order of penalty dated 15/3/2013. Hence the present petition by the state, hence the present appeal by the state. Full stop. Next part. Learned counsel for the state restricted his argument that the learned single judge should have remanded the matter to the disciplinary authority instead of merely quashing the order of penalty. Full stop. He has pointed out that in the inquiry there is a non-adherence to sub-rule 14 of rule 17 of BR CCA rules so and so. Therefore, penalty order was set aside on technicality. To stop, it is further submitted that the alleged charge is in respect of certain financial loss due to alleged negligence on the part of the respondent. Therefore, it is a case for remand in terms of the apex court decision in the case of MD ECIL versus so and so B Karunakaran, read with Coal India so and so. To stop. Per contra, Land Council for the respondent resisted the aforesaid contention and submitted that alleged allegation is relates back to 2000 relates back to of the year 2008 and 9. Departmental inquiry was initiated on 5/11/2009 and it was concluded on 15/3/2013. In the meanwhile, a respondent attained age of superannuation and retired from service on 30th June 2008. In the light of these facts and circumstances, question of remanding the matter to commence the inquiry from the defective stage is not fair and proper for the reasons that petitioner department have taken about 4 years in initiation and completion of inquiry. First, heard the land councils for their respective parties.
And no pecuniary loss, my lord.
Huh?
And no pecuniary loss occurred.
No loss.
Due to it is stated
It
in
was
the
also
inquiry
submitted
report.
that no loss has caused to the state exchequer.
Because contractor has found guilty for that return. Contractor is found guilty for return the money. It is stated in
It is
the
also
inquiry report.
submitted that the alleged loss amount has been paid by the contractor.
Yes.
In support of the same, full stop. Heard the land councils for the respective parties. Undisputed facts are that the respondent was an executive engineer, full stop. While he was discharging the duties of the post in the year 2008 and 9, petitioner department noticed certain irregularities stated to have been committed by him. Based on such allegation, departmental inquiry was initiated on 5/11/2009 and it was concluded in imposition of penalty on 15/3/2013 to the extent of withholding of 40% pension of the petitioner of the respondent for a period of 10 years. Feeling aggrieved and dissatisfied with the order, respondent prepared a writ petition number so and so, and it was decided against the petitioner department. Thus, the present petition. The state the appellant counsel for the state had restricted his argument only to the extent that matter is departmental inquiry is required to be remanded to the disciplinary authority / inquiring authority to commence inquiry from the defective stage, and he is not aggrieved by the reasoning assigned by the learned single judge in quashing the penalty order. In support of the aforesaid contention, he relied on apex court decision MD ECL so and so and Coal India. On the other hand, learned counsel for the respondent submitted that the petitioner department have already taken sufficient time, and further no loss has caused. However, at the same time, it was submitted that whatever the loss alleged to have caused to the state petitioner, it was remitted by the contractor. Full stop. To that effect, he has not furnished any documentary evidence so as to reconcile the alleged loss is alleged loss stated to have committed by the respondent. Full stop. Therefore, we find prima facie case that the learned single judge has erred in not remanding the matter to the inquiring authority slash disciplinary authority to commence the inquiry from the defective stage. In other words, compliance to sub rule 14 of rule 17 and other provisions of the rules 2005, CCA rules 2005. Full stop. We would not have remanded the matter to the disciplinary authority having regard to the fact that 4 years time has been taken consumed by the petitioner department in initiation and completion of inquiry, and respondent has attained age of superannuation on 30th June 2008 itself. Full stop. However, having regard to the allegation that there are financial irregularities, therefore we are compelled to remand the matter to the inquiring authority to commence the inquiry from the defective stage and complete within the time limit. Full stop. In fact, the present matter is squarely covered by the Apex Court decision in the case of MD ECIL versus B Karunakaran, reported in so and so, read with Coal India so and so, para 48 to 50 reads as under. In the light of the aforesaid decision and the fact that the penalty order has been set aside by the learned single judge on technicality, and further there is alleged financial irregularities stated to have been committed by the respondent. Full stop. In the light of these facts and circumstances, order of the learned single judge is modified to the aforesaid extent in remanding the matter to the inquiring authority to commence inquiry from the defective stage and complete within a period of 4 months from the date of receipt of this order, failing which it is held that inquiry proceedings stands abated. The respondent is hereby directed to cooperate in conclusion of the inquiry from the defective stage. In this regard, the inquiring authority slash disciplinary authority is hereby directed to issue notice in advance for his appearance from time to time.
Serial number 3, Khalid
And this
Ahmad.
4 months will not apply, my lord, if the petitioner writ petitioner does not cooperate.
Your inquiry officer has to record.
Pass an order.
He has to record. He can go ahead with the ex parte if he does not appear.
वो अगर इंडिकेट हो जाए तो
हाँ?
वो इंडिकेट ऑर्डर में हो जाए कि if he does not cooperate then next party we can move.
That is
That
no, you
discretion
have
is
a-
already there. I am
under the
conscious.
rule it is provided. You go ahead.
After my lord, the judicial pronouncement
If he
work feels
if he
difficult.
absents himself, just record his absence and
You
move.
can give 2-3 dates, record, and close it.
Date-
Any
date-
further advice you want?
Pardon?
Any further advice you want?
नहीं नहीं advice I do not know.
Yes, yes.
Serial number